Good morning. Thank you for joining us here at PASR. Today we have Jessica Fisher-Greene and Megan Straight, both of Walters and Galloway. And today they're going to do a presentation on power of attorney and guardianship. So thank you for joining us today.
Thank you for having us. Good morning, everyone. Thank you for logging on. And for those of you watching later, hope you can get a lot of your questions answered. So I'm Jessica Greene. Also, Megan Straight will be speaking in a minute. I'm going to be focusing on the power of attorney aspect, whereas Megan will get into the guardianships. And we'll get right into it.
Great, thanks, Jessica. I'm Megan Straight. I'm also with Walters and Galloway. And as Jessica said, one of my focus areas at the practice is in guardianships. So I'll be talking to you today about the guardianships. And then Jessica's going to tell you more about the powers of attorney. And we're going to do a presentation that's kind of along the lines of the differences between the two and pros and cons. So I'll go ahead and get us started. Okay, so our agenda for today is to start with just a basic overview of guardianship and then transition into an overview of powers of attorney. And then we'll talk about the different responsibilities under guardianship and under the powers of attorney, and then we'll talk about reporting requirements. So what is a guardian? A guardian is a fiduciary that's responsible for the care and management of the estate and or person of an incapacitated person. And I know that probably sounds a bit confusing. So I'll try to explain it in a more simple way, but a guardian is that person who is appointed by the court to look after an individual who has been determined to no longer be able to care for themselves or manage their own finances. But the legal system uses the term estate to reference financial affairs, and they call guardian of the person. They use that term when they're describing someone who's in charge of taking care or making healthcare decisions and general maintenance for an individual. And then it's important to know who can serve as a guardian. So really anybody can serve as a guardian. They do have to submit a criminal background check if you're just an individual. But there's also agencies that will step in and serve as guardians as well. But anybody can really do it.
So power of attorney, hopefully most of you have heard of the term power of attorney. And this document will cover both financial and legal decisions, as well as healthcare decisions. And it used to be years ago that we had everything lumped into one big general power of attorney. It was kind of the longest run-on sentence you had ever seen, and it was supposed to cover everything. But now we really separate these out. So we have a durable financial power of attorney, and then we have the durable healthcare power of attorney. So in both documents, you are choosing someone else, that person is called your agent, to make these decisions for you. But like I said, depending on if it's the financial power of attorney or if it's the healthcare, will determine which types of decisions they are making. If it's the healthcare power of attorney, they are controlling your medical decisions. If it is the financial power of attorney, then they are deciding on your financial and legal decisions. And the term durable means that this document will still work even if the person becomes incapacitated. So that's really important because that's when you actually need the document to come into play. So who can serve as your agent? Hopefully it's someone that you trust and you know really well, will follow your wishes. They'll open the mail, they'll answer the calls, pay your bills on time, do everything that you do on a regular basis when it comes to your handling of your finances. And then also when it comes to your medical decisions, they really are stepping into your shoes to make those decisions for you.
So transitioning back to guardianship, the question is, when is it necessary to have a guardianship? And the two key factors that the court considers are a person needs to be determined incapacitated, and there are no less restrictive alternatives available. So when you look at that first prong regarding incapacity, that's a determination that's made by a medical professional. They go through an evaluation of the individual to determine whether or not they are able to care for themselves, if they're limited in doing daily activities. They really go through an extensive assessment to determine if they have the ability to provide any care for themselves, if they understand how to take care of their finances or whether they don't. And then they render an opinion. And then that doctor is often called into court to testify, to render that opinion on the record before the judge to make that determination of incapacity. And then if you look at the second prong, it's called no less restrictive alternatives available. And what that means is initially the person has never done any sort of powers of attorney, either financial or healthcare. They don't necessarily have anybody, any family members or representative payees associated with accounts that could assist them. You really have to think of it as this person is on their own or was on their own, and there's no one available or designated to assist. That's what the court is looking at when they say no less restrictive alternatives available. It has to, guardianship is kind of known as like the end all be all last resort for a court to impose. So if a person does have powers of attorney in place, or they do have, on occasion, they have their finances wrapped up in a trust account and they have a trustee, the court may make a determination that a guardian doesn't need to be appointed over this person because they have enough tools in place to not need that. But those are the two factors that the court has to look at and weigh before determining whether or not to appoint a guardian over somebody else.
So back to power of attorney, when can you make one? Two main requirements here. The first one, pretty easy for us to determine if the person is 18. Look at their driver's license. I think, I'm not looking at anyone's IDs, but I think everybody on here might be 18 or older. So we probably have that one down. But the next one is a little trickier. We have to make sure that the person who wants to create this document has the capacity to do so. So they have the ability to understand what they are doing when they create this document. It's really almost like they've entered into a contract, and in there, you know, they're almost in this agreement with the agent of what the agent is going to do for them, what powers the agent will have, what property you have that the agent will have control over. We really need to make sure that when the person is creating this document, they understand all of this before they can actually sign the document.
And just one note on that, the key difference between capacity and guardianship and capacity when doing a power of attorney is the attorney assisting with preparing the documents can make the determination of capacity of the person signing the power of attorney, whereas I had mentioned a doctor actually has to render an opinion regarding capacity if you're proceeding with guardianship. So obtaining guardianship, I think by now you've heard me mention court and judge multiple times. So it's no surprise probably that you do have to file a petition with the court, asking the court for guardianship over an individual. And the question becomes, who can do that? Can anyone petition the court and seek guardianship over me? And the answer is it's a little gray, but maybe. They do have to have some sort of interest in your welfare and well-being to be able to substantiate their basis for petitioning the court to ask the court to appoint this person to oversee your financial and regular daily care and management. So when you think about who could that be, oftentimes it could be a family member. It could be a friend that you have that's assisted you regularly in your daily life. Anybody who really can establish that they know you and have an interest in your well-being can petition the court asking for a guardian, but they still have to obviously establish those first two factors of incapacity and that there's really a need and that you don't have any less restrictive alternatives available. And then after the petition is filed, the court typically will automatically set a day for a hearing. And that's when the petitioner who filed seeking guardianship over an individual will present their evidence to establish that the person is incapacitated and that there's an actual need for a guardian of this person.
All right, so when we're creating that power of attorney document, typically this is prepared by an attorney. And in that process, as Megan had mentioned, we're determining that capacity component. It's not a doctor coming in and determining if the person has the ability to do certain things, but in fact, it's the attorney who's asking, you know, whether they understand what's in the document, the person they're choosing, if they're a good choice, the powers that they will have, the property that's controlled by the document. These are all determinations that the attorney is making. Now, I will warn you that if you went online and looked up power of attorney, there are plenty of online forms, but the more and more we see of these, the more problems that occur, because Pennsylvania is a very specific state about our requirements. So you can see there that we require a notice, which is the cover page to our document, and it has to have specific language that must be in all caps and be bold. And there's a page that the agent signs. So the page that the agent signs is where they're acknowledging the powers and duties that they have as the agent. So if you get a document, say online, and it does not have these two really important parts, the document is not valid and will not be honored in Pennsylvania. Also, the power of attorney must be signed in the presence of 2 witnesses, and it must be notarized. So a lot of those forms that we're seeing do not have the most updated requirements, and people are only signing it and not getting it witnessed, or they're not getting it notarized, and it just seems like they're not on the same page yet. So it's really important to make sure that you see an attorney about this and it's someone who really focuses on this area so that you can get exactly what you need. And we'll talk a little bit more later about specific powers that have to be mentioned in the document for it to really work for you.
So when you look at guardianship, there are different types of guardianships that can be awarded. It's not a one-all be-all. So first, you look at whether there is a need for just a limited guardianship or whether there's a need for what they call a plenary guardianship. And the plenary guardianship is sort of that overarching broad power and authority to act as guardian over an individual. And limited would be probably just what you're thinking. The guardian has some sort of limited capacity to act on behalf of that person. And that could mean with respect to their finances or just care and maintenance. And it could be for a short duration. But regardless, if a guardianship is imposed, the only way to vacate that guardianship is through a court order. So the court would first determine that whether they can do a limited guardianship and still leave the person with some sort of independence, or whether they have to impose that plenary guardianship where it's just an overarching broad authority, and in essence basically stripping that person in need of a guardian of any rights to act on their own behalf. And then, as I mentioned really early on in the presentation, the court does outline the two specific types of guardianship. And it's very detailed in any order that you would see for guardianship. They specifically state whether or not the guardian that's being appointed does have authority over the person and estate, or whether they just have authority over the person or authority over just the estate. And as I had mentioned earlier, guardian of the person is kind of just what you would think. It's the authority to assist the person in making healthcare decisions, providing for their daily care and maintenance, anything related to the person itself. And then the guardian of the estate is all of the other things. So the financial matters that you handle on a day-to-day basis, any legal decisions for that person, that is what the guardian of the estate encompasses.
So types of power of attorney, not quite as complicated as in the guardianship world, but as I said earlier, it used to be just a general power of attorney. And you may have one of these older general powers of attorney where everything is covered in that one document. But since the laws have changed over the last few years, it really makes more sense to separate them out. So we have the durable financial power of attorney, with the financial and legal end of it, really listing out, all the powers that the agent can do. Can they deal with joint accounts? Can they change beneficiary designations? Can they, sell your real estate? All these types of things would be in the financial power of attorney. Whereas the healthcare power of attorney is going to come into play where the agent is going to decide, if you need surgery or tube feedings, maybe you need to go into a certain type of care community, or you're in and out of the hospital. Your healthcare agent is going to make that decision. A really big difference between the two is that with the durable financial power of attorney, that document is effective immediately. Your agent can start helping you from the minute you sign on the line. Whereas for the healthcare power of attorney, your agent is not going to start having power until you cannot make a medical decision for yourself. Big distinction there that I wanted to cover.
So now we're going to transition into the powers and responsibilities under both the power of attorney and guardianship. And we'll start by talking about guardian powers and responsibilities and what happens if a limited guardianship is awarded. So if the court determines that a plenary guardianship is not necessary, but some sort of guardianship does need to be imposed, it's going to be on that limited basis. And whenever that occurs, the powers that are given to the guardian, they have to be specifically stated. So some of the examples for limited guardianship powers could be that the guardian does have the authority to provide general care and maintenance to the person. And that may seem like a very broad definition of a power, but that in essence does give the guardian the ability to make sure the person's receiving kind of their basic needs and necessities, so long as those are met. Another example is the order may say that the guardian does have the ability to choose a residence for the person. So if that means that the person is in need of nursing home care, the guardian may have the authority to do that. But without that power expressly stated, the guardian is not able to do those things. That authority still would lie with the person themselves. And then if we look at what does it mean to really be guardian of the estate? What are the responsibilities? What are the powers that are given to a guardian of the estate? I had said earlier that some of those responsibilities include managing the person's assets. That could be anything from, writing checks to pay bills to acting as a fiduciary and making sure if they have any investments that they're still being, invested in a manner in which the person themselves would have been doing. There are specific caveats where even if you do have that broad plenary guardianship of the estate, you may still need to go back to the court to ask for certain permissions. One of those permissions would be if you're going to spend what's known as the person's principal. So their assets that they had when they were petitioned to have guardianship. You may not be able to just spend those unless it's specifically stated in the court order. Another example is if the person who now has guardianship over them owned a home. The guardian cannot just sell that asset from the person's estate without prior court approval, or unless it was initially stated in their order appointing them. And then the last responsibility, which is really important to note, and I'll talk about in more detail towards the end of the presentation, is when you do act as guardian over somebody, you are required to file reports with the state. And like I said, I'll talk in more detail about what that means and what makes up those reports. And I kind of jumped ahead of myself, but this slide is outlining some of the other powers that typically are enumerated in a power of attorney and automatically given to the agent in that power of attorney document that are not automatically given to a guardian. Jessica had said there, in your power of attorney, you do have to specifically state whether you want your agent to have the authority to make beneficiary changes to accounts, whether or not you want to allow your agent to make gifts. Well, when you are appointed as a guardian over a person, the court does not automatically give those powers to the guardian. If if there does need to be a change to a beneficiary designation on an account, or there is a need to make a gift, the guardian has to specifically petition the court to ask permission to do those things. Even if the incapacitated person would have wanted that to happen, that guardian still has to ask the court for permission, and the court could say no. And if that occurs, then you can't get those issues or matters resolved. So there may be a time where you have a guardian appointed over you and they are not able to make gifts on your behalf because the court does have that ability to still control how the guardian acts.
All right, so I kind of mentioned these a little bit earlier, that there have been some major changes to the power of attorney law in the last few years. The big ones happened in 2015 and in 2016. So if your documents are older than that, I would say you definitely want to have those reviewed, because not only did that law change the notice and acknowledgement pages that I mentioned earlier, it also changed the meaning of certain powers in the document. And now it says that if you want your agent to have specific powers, your document must say that your agent has those powers. This is especially important when we're trying to protect assets from the nursing home. So I have some examples there. Your agent, in order to protect your assets from the nursing home, needs to have the right to make a gift, and not only any kind of gift, but unlimited gifts. So that needs to be specifically stated in the power of attorney document. Depending on the planning and what's going on in your accounts, you may also need to have the power to create or change rights of survivorship. So this is jointly owned accounts, dealing with those types of accounts or assets. Another item that I mentioned earlier, having to do with creating or changing a beneficiary designation. Let's say that right now, your primary beneficiary is your spouse, but your spouse goes into the nursing home. Probably don't want to name your spouse directly on that anymore. But what if you don't have the ability to change the beneficiary anymore because now you have lost capacity? That's why it's important to have your power of attorney give these powers to your agent, so your agent can make changes as the circumstances change. Going on to the next slide, then there were changes in 2020 as well. Now, these mainly focused on your agent having the right to access your electronic communications and digital assets. So if you have any online accounts, anything like this, take a good look at your document. It may be time to update so that your agent can actually handle those accounts for you when you're not able, or you just, don't want to do it anymore. Really important to make sure that you're looking at these documents and making sure they're up to date every few years.
So now we're going to move into talking about the guardianship, or the guardian's powers and responsibilities when it comes to the person. And what does that really mean? So some of the duties that a guardian may have can include asserting the rights of the person. So with respect to having or needing certain surgeries, certain medical care, the guardian of the person has the ability to advance those initiatives on behalf of that alleged incapacitated person that they're overseeing as the guardian. But they do have to do that within certain bounds. So they do have to respect the person's wishes and preferences if they knew what those were beforehand. So for example, if you knew that somebody had made, funeral arrangements ahead of time and they knew whether or not they wanted to be buried or they wanted to be cremated, as a guardian, you still have to respect that person's preferences. And same with any sort of medical treatment. So if you knew something about the person that you're acting as guardian over before you were appointed, such as maybe they don't want to be given antibiotics when they're at an end stage, then you need to kind of abide by that, even if it's not expressly stated in the court order. The guardian over the person, they're able to develop plans for support of the person. That can include placing the person in a nursing home. That can mean hiring and firing individuals for in-home care and nursing services while remaining at home. Very similar to some of the authorities that you're given if you're acting as the power of attorney. And then there's always that caveat that the court includes, which says, even though we've determined the person to be incapacitated, to the extent possible, they're able to participate in a decision. We encourage the guardian to include them in that decision. And that could again be anything from placement in a nursing home, hiring in-home care, taking care of their basic needs, making sure they're getting the appropriate medical attention. While we've determined the person to be incapacitated, there's still that ability for the person to act on their own so long as they're able to do so in their own best interest and they're being protected. And then just like with guardianship of the estate, there is that filing of reports that needs to be done even with guardianship of the person. And like I said, I'll talk more in detail about those reporting requirements towards the end of the presentation. So just like with the powers and responsibilities for the guardian of the estate, there's certain powers and responsibilities for the person that you're not going to be given right away and that you have to seek court permission for. And those powers are outlined on this slide. And those would be things regarding consenting to an abortion on behalf of somebody that you're acting as guardian over, any sort of sterilization or psychosurgeries or electroconvulsive therapies, or even removal of organs. The guardian cannot make those determinations alongside of a healthcare provider without having a court order giving them the authority to do that. The same thing with prohibiting the person from being married or divorcing their spouse. Even though there's a guardian there, that guardian cannot prohibit the person from wanting to get married. There may be other things that prohibit the marriage from occurring, such as the person really truly does lack capacity in that moment to understand the decision they're making, but the guardian doesn't automatically have that authority to stop it. And the same with consenting to a divorce. A guardian cannot consent to a divorce on behalf of that person that they're acting over without the court allowing them to do so. And then any sort of experimental procedures or treatments. If the person were to have cancer and the guardian thinks it's a good idea to enroll them in some sort of test study for a new medication, they cannot do that before seeking court approval to do so. And then there's just certain powers that the guardian over the person is not going to be able to have. And that's consenting to the admission of a person to a psychiatric facility or state institution If there's an absolute need, they can certainly go back and seek court approval for that, but they're not going to be given that power initially. And then they cannot consent to the termination of parental rights under any circumstance. So if somebody's been deemed to be incapacitated and has a guardian acting on their behalf, and they still have minor children, the guardian cannot consent to terminate that person's parental rights under any circumstance.
So shifting gears from that financial and legal power of attorney, moving on to the healthcare power of attorney. But before I get too deep into that, I do want to note that, you know, throughout the guardianship powers and everything that Megan has mentioned, you know, there's often the mention of a filing of a report, and, you know, it's really stringent, a lot of requirements and rules with that. And as I'm talking about power of attorney, it's a lot simpler, you know, and you'll kind of see as we get through this that really power of attorney is something that is our first choice, you know, and we want you to get that done while you have the ability to do so, because we're really only doing guardianships when it's, as Megan mentioned, we have no other, you know, less restrictive alternative. We have nothing else that we can do. It's really our last resort. So when we get into the healthcare power of attorney here, like I said earlier, it's the agent who is controlling your healthcare decisions, but it's only when you are unable to make the decision. So as long as you're able to communicate what you want to have done, your healthcare power of attorney agent is not going to step in and take over. In this document, there's also a HIPAA waiver. I'm sure everybody's heard of HIPAA. And in there, it's allowing your agent to see your medical records to help you make an informed medical decision. So that HIPAA waiver is actually effective immediately because that's required under the law for that to be an effective waiver, but the rest of the document is not effective until you cannot make the decision. So some examples of powers that you'll find in the healthcare power of attorney, it really gets into, you know, specific items. So your agent can authorize, withhold, or withdraw any sort of procedures that you might need, whether it's a surgery or a general medical procedure. They can deal with any sort of tube feedings, whether they're authorizing, withholding, or withdrawing it. And they can authorize your admission or discharge from any sort of care facility. So it's really important to make sure that the person you have chosen for that role really understands what your goals are. You know, when would you want them to withdraw a tube feeding, or when would you want to be admitted to a facility? You know, really talking through all of that and making sure that you've chosen the right person for that role. Some more powers that your agent will have: your agent can hire and fire anybody who's responsible for your, you know, care, whether it's social services, your support, any sort of medical care. And they can also take any legal action necessary to follow your wishes. So there are some hospitals that will not follow a living will or a DNR. It's against their practices, it's against their beliefs, so they're not going to follow that. But your agent can take action to have you transferred to a hospital or a doctor that will follow your wishes. So this gives them the ability to do so. They can also request a DNR, which is a do not resuscitate order. And there are different types. There's in the hospital, out of the hospital, and this gives them the ability to really follow through on your wishes. And then this is a big one that was added with the law change. It has to do with organ donation. So it used to be that your agent could authorize just really traditional organ donation, but now it's been separated out to distinguish between traditional organ donation and tissue and the vascularized composite allografts. More on that, I think, in the next slide. So in the in the healthcare power of attorney, you can also use this to lay out any sort of burial or cremation wishes. It used to be common practice to put your burial or cremation wishes in your last will and testament. People would often write in there, I want to be buried at this cemetery and pay for my, final interment at that time. But we're finding that most people are not looking at the last will and testament until you have already been buried and all of that has already been taken care of. So it creates a big issue because, let's say your executor already said, okay, we're going to cremate her. And then they look at the will, they're like, oh no, she wanted a burial. So it's a lot better to have it laid out in this document because everyone is looking at this document while you are still alive. So that way everyone is on the same page. And especially if you have prepaid for anything, you want to make sure that your agent is aware of that. And it really does make things a lot simpler and easier on the family if they know exactly what you want. In this document, you can also decide if you have severe brain damage or brain disease that's not going to get better. And then you have a life-threatening condition on top of that, like a heart attack. Do you want them to treat you for the heart attack? Or do you want them to just keep you comfortable and kind of, let you move on? These are the decisions that you're going to make in the healthcare power of attorney. Excuse me. In the living will, this document is different from the healthcare power of attorney because this one is looked at when you are permanently unconscious or you are at the end stage of a terminal medical condition. So the healthcare power of attorney we were looking at when you were just unable to make your decisions for some reason. Maybe you were in a car accident, you were temporarily knocked unconscious, your agent was able to make those decisions. But in this one, it's all permanent. You're not going to get the ability back to make those decisions. So now you're directing, if you truly are at the end, you're not going to get better. Do you want anything to prolong your life? Or do you want to focus on pain relief and comfort? These are the decisions that you would make in that document. In the living will, you're also going to be addressing whether or not you want tube feedings or hydration through a tube. This really all started years ago with the Terry Schiavo case. Not sure if anyone remembers that case about the young woman in Florida who, had an incident. They were saying possibly she was had no brain activity, but yet, there was this big fight between her parents and her spouse about when and how to withdraw the tube because she didn't have anything in place about what her wishes are. So now this is so important to have this in the document. If you do not have brain activity or if you're at the end stage, whatever it might be, do you want that tube feeding or hydration through a tube? We can also keep it pretty flexible in the document. There's a place in there where you can say, if you want to require your agent to follow these instructions, or if you want your agent to use these instructions as a guide, but you trust them to have final say. And then there is a legal protection clause because a lot of people get nervous about making these huge decisions for someone. So there is a legal protection clause in there that says as long as your agent is acting in good faith when they're following your wishes, if something goes wrong, they're not going to be held liable for that. So here are some of the changes that I was mentioning that occurred effective in 2019. There had been some huge conflicts in the documents when it came to organ donation because on the one page you're saying, I don't want anything to prolong my life. Please do not put me on any breathing machines, give me any tubes, none of these things. But on the next page, you're saying, please, I want to donate my organs. Well, there's a conflict there because in order to donate your organs, a lot of times the doctors in the hospital have to keep you on machines to facilitate the transfer process. And now we have in the new document, it's saying that I acknowledge that I've said I don't want to be on machines. But if I have to be on a machine in order to make the organ transplant process occur, I'm okay with that. So that's something that if you are an organ donor and your documents are older than 2019, I'd really take a hard look at them and make sure you have this updated language. There has also been a distinction between traditional organ donation and the donation of your hands, facial tissue, limbs, and other vascularized composite allografts. If you want to only donate the traditional organs and tissues, you would state that in the document. But if you want to give these additional items, you would add that as well. Now, the organ donation designation on your driver's license is just defaulted to the traditional organs and tissues. If you are interested in giving these additional items, you need to have this document detail that, otherwise they will only take the traditional ones.
All right, so this is what I've been promising now for most of the presentation, and that is information about guardianship reporting. And as you've heard us say, and probably as you've learned today, both guardianship and powers of attorney are very similar in the powers that are given to each, the agent in the power of attorney and the guardian in a guardianship case. But the one key difference is this reporting requirement. As a guardian, so in essence, a court-appointed official, you are required to file reports. And there's 3 different reports that are required. The first report is an inventory, and the second 2 reports are report of the person and the report of the estate. And I'll talk first in more detail about that inventory report. So that inventory report is a report that only needs to be filed once, but it must be filed within 90 days after being appointed by the court as guardian. And that report has to show all of the person's assets, sources of income, any debts that the person has, and it has to answer questions about the guardian status. So it does provide a history and overview of the guardian itself. It also has to detail a personal care plan and financial plan for the individual who now has a guardian appointed over him or her. So the guardian has to outline what is it that they're going to do on behalf of this person. And it also has to contain the person's medical information. And again, the key thing to note is that report is required to be filed within 90 days after guardianship is appointed. Now, with respect to the other 2 reports, I'll talk first about the report of the person. That report is required to be filed annually. And the due date for that report is 1 year after the court has appointed the person to act as guardian. And it's every single year, not just once, like the inventory report. So each year, the guardian has to submit to the state a report that contains personal information on the person, so name, address, whether the person has changed residences in the last year, whether they're remaining still in the same location. It has to include all of their medical information, including doctors that they've seen, if there's been any changes in their medical conditions within the last year. All of that has to be noted in this report that's submitted to the state to review. And then it does allow for the guardian to kind of render their own opinion, It's not an expert opinion by any means, but just kind of advising the state as to the status of this person when it comes to their physical condition. And then that last report that needs to be filed is the report regarding the estate of the person. And again, that one must be filed annually as well, and each year, not just once. And that report has to include a lot of things that are similar to what was included in the inventory, which is the person's sources of income, any expenses that they incurred over the year, if they acquired new assets or got rid of any assets. That all has to be noted in that report of the person. And then if there were any professional fees that were spent on behalf of the person, that needs to be noted. So if you do have a corporation or agency acting as guardian, they may charge an annual or monthly fee. They have to disclose that on their report. Same if they hired any other sort of professionals to act on this person's behalf throughout the year. It has to be noted in that report. And then lastly, the guardian has to provide his or her information, and if there's been any changes to their location as well, so the state can keep track of where the guardians are actually located.
And I kind of alluded to this earlier, and just to really kind of hit it home, you know, Megan just went through all of that. That's really, really complicated, very cumbersome. Probably need to hire an attorney to help with that. Whereas for power of attorney, there's really no reporting. So get it done while you can and save a lot of time and hassle and money for everybody involved.
Absolutely. So that concludes the presentation. If anybody has questions, I believe we have a few minutes for some questions. So we welcome those.
So there are a few in the chat, Megan. I don't know if you saw that. There was one, I think that's directed at you. What if I plan to be the guardian and I am in PA, but the person is in Maryland? Will I follow Pennsylvania rules?
So no, when it comes to what we call jurisdiction, jurisdiction lies where the person who's going to have that guardianship is residing. So if the person is residing in Maryland, has a residence in Maryland, will be living in Maryland, then the guardianship would be through the Maryland court system.
All right, and then the next one I think was for me. Is there an age at which your organs would not be used for donation, even if all other requirements are met? So currently there is no maximum age that is looked at. It's really about the quality of the organs and not the age of those. I believe a couple years ago, there was a 92-year-old that had donated. So certainly, you know, you're never too old. If you're interested, leave it up to them to decide what's good, just by marking that box on your document. But it's a completely personal preference. So whatever you decide, you know, is best for you is what you should write down. Another question here, is there any reason to set up a POA for my spouse, or is this not necessary between spouses? So we love this question. It's really a common question. And, you know, people will say, well, I own everything jointly with my spouse. I probably don't need a power of attorney for my spouse. Well, actually you do. A couple of reasons. And so I had a case a few years ago where husband and wife, wife had developed dementia, husband was really making all of her decisions. And then she needed a non-emergency procedure. And the doctor's office would not let husband sign because this was not an emergency situation. And we actually had to go for guardianship for him to be able to make those decisions for her. So just because you are a spouse does not automatically give you the right to make, you know, medical and financial decisions for someone. It's especially important too, with the financial end of it. Sometimes you can get away with it on the healthcare, but for the financial, you know, let's say you jointly own your house, but one of you has now gone into the nursing home. Well, we would want to transfer the house out of that person's name into the other spouse's name alone. But if we don't have power of attorney for the person who went into the nursing home, we cannot make that transfer. Even if you wanted to just sell your house, you still need power of attorney for your spouse to be able to sign for them on that transaction. And what if your spouse has an IRA or life insurance, something that's in their name alone, but you're the beneficiary? You have no rights to it. You cannot call or do anything with it without being power of attorney. Another question, can you give any comments concerning donation of body? Not really sure what you're asking for there. Like I mentioned earlier, there's no age requirement, and certainly it's a personal preference, and you want to make sure that you have really updated your document if that's something that's important to you, because in there you can distinguish between if it's something you want to keep just as traditional organ donation, or if you would like to give those additional items, the facial tissue, the limbs, things of that nature. Okay, so they did a follow-up on that. Donation of body options to hospital, teaching institutions. Yes, so if you're interested in donating your body to science, or to any specific organization, I know that many of the hospitals in this area, like Hershey, for example, you can fill out a form and get everything set up with them where you can donate your body to them, and you get a little like card that you can keep in your wallet. There are other organizations and hospitals as well that you can work with, especially if you have a specific interest in a group, like maybe Parkinson's or Alzheimer's. There are ways to donate specifically for research for those organizations as well. And then my parents are each other's power of attorney, and I am second on the list for durable financial power of attorney. I've been paying their bills for 4 years, but I'm unable to talk to companies without their approval. How do I get the power to do this? So if you are not the primary agent, couple options. Your parents could do a new document where they name you and the spouse at the same time, so you both have the rights to act. Your parent who's named in the primary role could sign a renunciation, which means that they're saying, I'm stepping down, and now the next person in line will take over. But something needs to happen with the forms for you to legally be able to take care of things for them and call companies and really step into that role. Any other questions?
If you don't know how to use the chat feature, you can certainly unmute yourself if you have a general question to ask Megan or Jessica. I'll give everybody a moment. So if there's no more questions, I want to make sure everybody has Walters and Galloway's information, which they have on the screen right now. They do provide a free consultation to our members, and if you are a member, you also get a discount. So, we're very grateful for your presentation today, and you provided a lot of valuable information. And I'm sure maybe people might have some more questions. This is recorded, so it will be available on our website very shortly. So I just want to say, everybody, thank you for joining us. If you're not a member, we are happy to have your membership, and the ladies here are happy to give you some more information if you need that as well. So call our office at 717-697-7077, and we'll be happy to hear from you, or if you have questions. So thank you, ladies, and thank you everybody who joined us today.
Thank you so much.
Have a good day. Take care, everybody.
You too. Bye-bye.
Yeah.